Hi there, my name is Jamal Khan. I'm a senior tax partner at Churchill Tax. One of our recent inquiries or clients that have been approaching us, we've been talking about incorporation or transferring properties into a limited company. There is also an important element to consider when incorporating or transferring properties into a limited company. One is something I call smart incorporation, which involves transferring properties into a limited company and setting up a family investment company at the same time. So hence the name smart incorporation. So first of all, what we do is we transfer properties into a limited company. We look at all the requirements. We look at whether there are enough properties. So people who come to me who want to transfer properties, could they own 2 or 3 properties that they want to transfer into a limited company? You have to ask the question whether it qualifies as a trade and whether you satisfy the 20 hours rule or not. You can watch some of my other videos which talk in detail about the 20 hours, but that's not the purpose of this video. The purpose of this video is about smart incorporation, right? So the main theme is you go through the rules, you check if there's a 20-hour rule is satisfied, you check if you have a partnership set up. So without a partnership, there's no point in incorporating because you'll end up paying a lot of stamp duty, and you have to make sure the partnership has been running for at least 2 to 3 years. Although there is no statutory minimum time limit, but we normally allow 2 to 3 years. So once that's done and you have transferred, then you go through the incorporation process, which is quite a tedious task. A lot of people make mistakes whilst transferring properties into limited companies. One of the things that people make, I've done quite a few webinars on this, where people make significant mistakes on transferring properties into limited companies. So once you pass that hurdle and you have successfully incorporated, now we come to the main topic of smart incorporation. So you've incorporated, the limited company set up, the properties are inside the limited company. Now, you need to think about inheritance tax planning at the same time, whether you want to convert this now into a family investment company after incorporation. So what we do at this point is we restructure the shares. So where there's 2 partners involved, they may have children, they may want to think about estate planning. So we issue a new class of shares called growth shares in the company. And you have to amend the Articles of Association for that. So once you've amended the Articles of Association, there's quite a tedious process. Once again, you have to make sure you get it right. Articles of Association have been amended, so you issue a new class of shares. The new class of shares have to be issued to all the shareholders. So for example, not just to the children, but all the shareholders. And to issue the new class of shares, you have to then issue, to make sure you set up a hurdle. So if the market value of the business is, or the company say 10 million, the new class of shares will start gaining value once the company hits say 11 million and above, or 10.5 million and above. So there is no capital gain tax on setting up of the new class of shares, which can be issued to the children. Right? So this is a very important point, hence we call it smart incorporation. Once you've issued the shares to the new shares or the growth shares to the children, you would the same would be issued to the parents as well at the same time. Or it doesn't have to be children; it can be your employees. You could be business partners. It could be anybody. It could be new management team that you want to bring into the business. And at that point, you want to then go back and freeze the value of the original shares in the business. So this is an important point to consider. So you would then change the Articles of Association, change the value of the original shares. So whatever value there is in the original shares, say 10 million, that will never increase after this point. 10 million or 1 million, doesn't matter, whichever you do. So the value of the shares will never increase. Those original shares will be frozen. So the growth shares will increase in value from this point, but the original shares will stay stay the same. And that helps with estate planning, because any growth in value, for example, if it's a real estate company, then any growth in value would go to the new shares. At that point, what you also need to do is for parents to gift before all of the value starts increasing. As soon as the new shares are issued to the parents, they would gift back those shares to the children. And once you gift the shares to the children, now the children hold most of the growth shares, or all of the growth shares. This is a very important tax planning aspect that people have been inquiring about. I've been helping a lot of clients with this, but so far I haven't done a webinar on this. If you are looking to incorporate, do not forget that you should also be considering turning this into a family investment company. At the same time, and with family investment company, you have to issue growth shares, in the articles of association, and freeze the value of the original shares. And that means any increase in value from that point onwards will go to the children, and that will help you a lot with your estate planning. Please get in touch if you've got any questions. I'll put my telephone number and my email address in the text below the video. Thank you very much. Thanks. Bye.